Okay, we should be live now. I was having a little bit of trouble there because I was trying to go live on Instagram, and we will see if we can make that happen. Let's see real quick if we can do that. Let's try. And let's see. Never gone live on Instagram before, so give me 1 second. Let's see if we can make that work. Copy that. And we're going to add save changes, and let's see if we can make that go. Doesn't look like it's going to work. Okay, well, we're not going to go live on Instagram, so we'll just stick with YouTube and Facebook. So maybe if it's on Instagram, that's great. I'm not sure if it is or not. Okay, anyway, I appreciate everybody here. Looks like we're up and running. Okay, the dude says I'm up and running. That is good to hear. And I appreciate everybody tuning in. Let me just take one more look here and see if we can add one more. Let's see if I can add LinkedIn here. And we'll see if it's working. Anyway, okay, so I appreciate everybody being here. Hope you're having a good week. Hope it's not too hot where you are. It is in Atlanta quite warm. I just got off the tennis court and it was a little warm. Okay, so today it's just going to be me. I was hoping to get a guest, but I could not get anybody. So it's just going to be me answering questions, and we'll work on that. So let's go ahead and start with some questions. We have, all right, so yeah, I was going to see if I could get Steph to join. Steph, if you're watching, sorry you couldn't join me this time. We'll do it another time. All right, Teresa says, just had a phone interview for both SSI and SSDI. I'm assuming you're talking about applying for benefits. And if that's what you mean, you are applying for both SSI and SSDI. What's going to happen now is your case will be assigned to someone at the state agency in the state where you live to develop the record. That person is called an adjudicator. The process of getting it from Social Security, the field office, to the adjudicator could be a week, it could be a month, it could be 6 months. Hopefully it won't be too long, but you'll get a letter from the adjudicator saying your case is now being processed. And at that point, it normally takes 6 to 10 months to get a decision at the initial application. The standard for disability for SSDI and SSI is the same. The question is whether you have the capacity to be a reliable employee, 8 hours a day, 5 days a week, because of a condition, a diagnosed medical condition that has lasted or is expected to last 12 consecutive months. So that's the definition. It's the same for SSDI and SSI. Now, interesting, I have a case on Friday where my client applied for both SSDI and SSI. In January of this year, they approved him for SSI, but not for SSDI. No idea why. So we've got the hearing coming up on Friday. And so obviously the risk is that the judge would deny him. I don't think that's going to happen, but it's kind of interesting that they approved him for SSI, not SSDI. It makes no sense, but you have two separate offices there. Okay. Good afternoon. Live in Alameda City, Bay Area, California. How long to turn into your retirement? Once you hit full retirement age, which will be 65 or 66, your disability will turn into retirement, and that happens automatically. But that is at full retirement age, and the amount you'll get will be approximately the same as what you're getting for disability. So disability and retirement are about the same amount of money. Okay, John asks, FCE, the functional capacity form, says sedentary work, which is the past work. He's 63. The PT, the physical therapist who did the FCE, did a medical resource statement saying I can only sit, stand for 20 minutes, other significant limitations. Doctor agrees RFC can be impacted. Yes, I think that is a very strong FCE because at 63, not only would you meet the grid rule if you're limited to sedentary, you'd meet it at light, quite frankly, but if you're limited to sedentary and no transferable skills because of pain or other non-exertional impairments, then you have a really good chance at winning. Plus, at 63, there has to be a minimal vocational adjustment when analyzing transferability of skills. So what that basically means is that if you can't do your past work or something almost identical to it, you win under the grid rules. So I think that you've got a really strong grid rule argument if you're limited to sedentary at age 63. Good evening from Florida, Otan. I have a question. How long can you be an SSDI as your limit? For 23 and I'm 50, for a 23-year-old and I'm 59 years old. There's no limit as long as you meet the definition of disability. If you were found disabled at age 25, you could be on disability for the next 40 years. Now, I will tell you that Social Security, not at this point because they've suspended all reviews, but when they do review people, the ones they review first are the ones who are younger, people in their 20s and 30s, because those are the people they're going to be claiming for the next 20 or 30 years. They're not going to spend a lot of time trying to review a person who is already 58, 57, because that person's really close to retirement age. So I wouldn't worry about it if you're in your mid-50s. If you're in your 20s, I think that's more likely you're going to get reviewed. Although at this point, I think as I've mentioned, the reviews have been suspended through the end of the fiscal year, which I believe is the end of September. So I don't think you have anything to worry about right now. Christina, who's a regular, hello from California. Hello, Christina. I know you had sent me an email or sent me a post back when I announced the live stream, so I'm glad you're tuning in again. I hope things are going well for you out in California. Chen, how about SSDI? Yes, I think I just answered that. SSDI can go on until full retirement age. You don't get them after you hit full retirement age. It is a different trust fund, but essentially you would continue to get them indefinitely. Minarni Chen, never absent from the video. Well, that is good. I hope that you find the value in this, and I enjoy seeing everybody here on Wednesday evenings, so that's good. I think we have 61 people here right now. Teresa asks, these are conditions: stenosis, degenerative disc disease, fibrosis, fibromyalgia. How long will it take for an approval? Well, first of all, realize there's no guarantees of approval. Obviously, I hope that you get approved, but generally speaking, at the initial application, it is taking now between 6 and 10 months to get a decision. If you're approved at initial, again, 6 to 10 months. If you're denied, you should appeal, file for reconsideration. A fairly low chance of getting approved at recon, about 15% of those cases are approved. And then if you request a hearing, that'll, the chances of about 50%. Hearing will be about 2 to 2.5 years after you apply. So best case is going to be around 6 to 10 months. More realistically, anywhere from 18 to 30 months before you get a decision and a hearing. And if you're asking me, is that too long? Yes, that is way too long. That is ridiculous. I think the commissioner knows it's ridiculous, but it is what it is. Carmen Ramirez, hello. Hello, Carmen. And it's Jonathan, not Mr. Ginsberg. I just had a birthday, so I'm already old enough. So just Jonathan is fine. Elizabeth, I think I've seen you here before as well. Anyway, you can have your case remanded to a judge about your back pay. All right, so you're raising an interesting point, Elizabeth, and that is you may have been approved, or two possibilities here. One is you were approved and Social Security changed your onset date to reduce the amount of months you were due for past due benefits. You can appeal that. I've got several right now that I've appealed, and my thought would be if it's $30,000 or $40,000, it's probably worth taking a chance. After all, they did approve you early on, so why not take a chance for that $30,000 or $40,000? The risk being that you could get a judge who pays at a very low rate, and you end up with nothing, and you actually end up having to owe them money. But I think it's pretty rare that actually happens, but it is a risk. So that is one thing. So yes, you can appeal a changed onset date. Whether to do so is a decision that you and your attorney would need to make. The other part of this question that I'm thinking, because I get questions like this sometimes, what happens if you've been approved and Social Security has not sent you your past due benefits, your lump sum? What can you do in that situation? That's a little more problematic because that's really not a situation where you would have a chance, a request for a hearing, because I don't know what the issue would be. That's where I would reach out to your U.S. Senator or U.S. Congressperson to find out where your money is. And I've got a few like that where, my client, we've won. Some of them are getting their monthly benefits, but they're not getting their lump sum. And the question is why? And of course, I've got a few where I haven't gotten paid either. And they just, sometimes the case just gets stuck on somebody's desk and it becomes a real struggle to get that paid. But I think you need to stay on it, and again, get your congressperson involved. Annie says, when can an SSDI beneficiary start a trial work period? At 1 year after onset, at approval date? Okay. I got this question from somebody actually by email this morning, and the answer is, and think about it, if you are approved or if you're alleging an onset date, let's say you're alleging an onset date of September 2020, and you're approved, eventually approved at September 2020, then that is when your disability began. Set aside the 5-month waiting period, that's with payments, but the date you're onset, you're found disabled. So the trial work period can begin immediately. So I've had people, and I've had cases like this, where somebody files for disability, they go to work, and they're working over the trial work period amount. They're even working at SGA, and they're over SGA for 5 or 6 months. And then they say, well, does that mean I have to amend the onset date when I get in front of a judge because I went back to work? And the answer is no. You can argue that the trial work period applies before you're approved because, again, the approval is simply verifying or validating that earlier onset date. So I've had cases where somebody went back to work. The judge says, I'm going to count the first 9 months here as a trial work period, because that's the trial work period limit. And then after that, I'm going to consider this unsuccessful work attempt. So I had a person who worked for 15 months and still got paid, found disabled because they were actually, it became a closed period, but the judge gave that person an extra 15 or 16 months by treating the first 9 as trial work period, the next 6 as unsuccessful work attempt. It's rare that a judge would do that, but I had a judge do it. But you can claim the trial work period immediately. You apply for benefits alleging you became disabled in September of 20, you go back to work in September of 21, let's say you claim an onset of August of 20, go back to work in September of 21 through December of 21, that can all be considered trial work months. Now, there are some judges and some people in Social Security who will say, well, if you went back to work, that looks like you have capacity, and therefore they're going to ask you to amend the onset date. But you don't have to do so, and there's nothing in the law says you do. So trial work period can be used immediately after you apply. And again, strategically, whether it makes sense to do that's a different question, but it does not, there's no bar to doing it. Okay. Why would the judge deny you in your back pay for SSI? All right, realize SSI is a means-tested program. SSI, you get paid only as of the date you apply. So if you say, I became disabled in, let's just pick a date, January of 2023, but you applied in June of 2023, you only get paid starting in June of 23. You can't get paid prior to the date of application in an SSI case. SSDI, you can go back a year. Again, if you have an onset date a year prior to, or even 18 months prior to your date of application, you can get that extra year and put the 5-month waiting period before you become eligible for payment. The eligibility for payment is 1 year prior to application, but SSI is as of date of application. So, if a judge denied you, or you did not get past due benefits prior to the date of your SSI application, that's because the law does not allow you to get benefits prior to the date of your SSI application. All right, so I'm up and running, looking good, says the dude. That's good. Donna says, good evening. How are you doing? We've got a hello from New Jersey. Very nice. What do you need to focus on for your first CDR? Now, the question is, have you actually received a notice of continuing disability review? Have you been given the form? Have you, I don't know where you're at in the process, but let's assume that they send you the form, either the long form or the short form. And I'll show you what those look like here. Let's take a look first at the long form here. And let's share the screen. This is the long form for, oops, wrong way. This is the long form. It looks like this. Let me make it a little smaller there so it fits in one page. And you'll see there's a bunch of questions here. Your name, obviously, they'll ask you about, someone you can contact, the medical information, the medical conditions, height, weight, the last 12 months, have you gone to a doctor? Have there been any changes, et cetera, et cetera. And the short form is a different form. It's a lot shorter. Just ask you about earnings you've had, basically. My point, though, is that either way, when you're talking about a CDR, continuing disability review, the key thing to remember is the definition of disability. What does it mean to be disabled for Social Security purposes? And that is to have a medically determinable condition, a diagnosed medical condition, not something that you come up with, but something that a doctor's come up with, that basically says that you've got a diagnosed medical condition that reasonably and logically would prevent you from being a reliable employee. So again, the issue in a disability case is, do you have a diagnosed medical condition that would prevent you from performing reliably even a simple entry-level job? So imagine a job where you're sitting in a warehouse, putting ink pens in a box, you can sit or stand, there's no stress, there's no interaction with the public. Basically, it's a warm body job. If you can fog a mirror, then you can do this job. So the question is, do you have the capacity to do that, or do your medical problems cause you to take unscheduled breaks, to miss more than a day or two of work a month, to prevent you from focusing and concentrating, on your condition? Distractions, you've got to go and, I've had cases where people have to do infusions or take insulin or whatever it may be, that happens, every 45 minutes, and they've got to go to the restroom for 15 minutes. They've got irritable bowel disease where they've got to use the restroom at unpredictable times. So the question is, are you reliable? So when you fill in these forms and when you approach a CDR, just like when you're approaching a new disability case, how do you prove you would not be a reliable employee? That is really the main question in any disability case. Okay. You're very welcome there. Okay. Rick says, does unearned income reported to Social Security affect your hearing decision? No. Unearned income, and I think by that we could talk about dividends. That might be an example of that. Let's say rental income from something you're not actively participating in. It's just something that's passive to you. Maybe you got you inherited some money. All these things that are not reflective of work done for pay. If it's not work done for pay, unearned income, but it's still income, it may show up on your Social Security statement as unearned income. That does not affect you negatively for Social Security. All they're concerned about would be earnings from work. And again, if you have deferred compensation, you have accrued sick leave, you have money that was owed you for, let's say a commission that was based on work done a year ago, that does not count against you. They're going to ask, when did you last go into the work site and do the job as it was normally performed? And so, you can even argue that you became disabled while you're still working if you got substantial help from your coworkers. Now, that's a harder argument if you were there getting regular pay, but I've done that where I can move it back 2 or 3 months by saying that my client was getting so many special considerations that the work was not really being done at an SGA level, substantial gainful activity level. So that is how that would. Oh boy, that is how that would. Okay. Let's see here. St. Louis. Presidential court opinions, including Chevron, have required federal district court appeals to give ALJs deference in their SSI decision. Has this changed? We don't have and what St. Louis Grand is talking about is the Chevron argument was a Supreme Court decision that basically said that administrative agencies, that the courts were to give administrative agencies like Social Security deference. So even though Congress didn't pass rules, the administrative agencies like Social Security, the FAA, FTC, they did, and so that those should be given deference by the courts. Well, there was a case that came along, I don't remember the name of it, it was a couple of weeks ago, that basically the Supreme Court says, wait a minute, we think that Congress has overstepped its bounds in basically, I guess you could say, giving all these agencies all this power, basically allocating or deferring to all these agencies, and so that the agencies, their decisions, their interpretations are not necessarily going to be given precedential weight. And so that can really, if you think about it, that means all these decisions by Social Security, all their policies, all their procedures, all that stuff can be brought into issue. Now, we don't know where this is going to all end up. But I think, as far as whether the federal court and the appeals court are giving ALJ's deference, ALJ administrative law judges deference, I don't know that they necessarily do. I mean, they're going to look at that and say, did the judge apply the law? So they're actually reviewing the ALJ's interpretation. So they're not giving it deference there, but I guess there is a part of it where there are certain parts that the federal courts are not going to look at. They're going to get, they're going to assume the ALJ's, evaluation of the evidence is correct. So your point is well taken. It may be that the way the federal courts start to evaluate unfavorable hearing decisions could change. We do not know right now. The case that was, let me see if I can get you the name of the case. If you want to look it up, that overruled Chevron, overturned. It is called Loper Bright Enterprises. And basically what the Loper case was about, I believe, was some fishermen. I think it was there's an agency, I don't remember the agency, that issues rules about what fishermen have to do and some of the things they've got to have on their boats. And so basically they basically told the small fishermen, you've got to have this very expensive, either a person or some sort of device on your boat that would basically put him out of business. And so the fisherman obviously didn't do it on his own, but he got somebody jumped in and funded it. And that's what kind of got this all taken care of, or knocked out. So the point was in Loper, the courts basically said that the agencies have been kind of running amok in that they're making all these rules, and the Congress is supposed to be passing the rules, and they can't simply pass the buck to the agencies. So the answer is we don't know what the impact of Loper is going to be on some of these Social Security cases. Now, what's going to happen is there will be decisions, there will be appeals made to federal court, and I suspect that the attorneys who do that, and in fact, I spoke to one of them, Brian Konoski, who's a friend of mine who does federal court work, and I'm going to get him on in the next few weeks, and he'll maybe be able to give us a better idea as to what the impact of the Loper decision might be on Social Security. But I think that at this point, the courts have not ruled on how far this is going to go, so I don't have an answer for you at this point. Okay, Naturally Jessica. Reconsideration stage for myasthenia gravis, autonomic dysfunction, POTS, likelihood of approval, not good. At Recon, only about 15% of cases are approved, and those are usually cases that are grid rule cases or listing level cases. And, the conditions you're describing here are not likely to get approved early. These are cases that are going to go to a hearing. So my guess would be it's going to be, and I will tell you, myasthenia gravis, those are hard cases. I've won a number of autonomic dysfunction POTS cases. Myasthenia gravis, it's, I'd say, maybe I win 1 out of 5 of those. They're just, some judges just don't think that there's, it's disabling. So that's going to be an uphill battle. The POTS and the autonomic dysfunction, I've actually had a little better luck with those. So, but I don't think you're going to win at Recon, unfortunately. I think this is going to go to a hearing, and you hope you get to a judge who understands what these conditions can do and what they mean in terms of how they affect your functioning. Jerry says, is driving a tow truck unskilled work? I'm self-employed in Recon, don't have employees, don't do invoices. Driving a tow truck, let's take a look at occupational info, and I'll let you watch me as I do this. Okay, so let's look at occupational info, and we'll see tow truck driver. Okay, tow truck operator. This is considered to be a medium job, 25 pounds frequently, 50 pounds on occasion. SVP3, which is low-end semi-skilled. So it's not a highly skilled job. It is low-end semi-skilled. It's the lowest semi-skilled job you can get. SVP 1 and 2. SVP, by the way, stands for Specific Vocational Preparation. Let me just move this up so you can see it a little bit better. But SVP stands for Specific Vocational Preparation, and SVP 1 and 2 are unskilled jobs let me remove that so you can see what I'm looking at here. I don't know why. Not sure why you're not seeing what I'm seeing here, but okay. Anyway, I will just tell you that SVP 1 and 2 are unskilled. SVP 3, 4, 5 are semi-skilled, and as a semi-skilled, let me go back and try this again, because you're not seeing what I'm seeing here. Let's try this again here. And tow truck operator. There we go. Okay, so you'll see here that SVP, or specific vocational preparation, of 3. That means it is semi-skilled, but 3 is the low end of semi-skilled. It's unlikely there's going to be any transferable skills to, this is a medium to light or to sedentary. So for grid rule purposes, if this is your past work, this will make it easier to meet a grid rule, if that makes any sense, because you've got a low-end semi-skilled. This is a medium job. I cannot imagine that there's any jobs involving tow trucks, or anything that's related to that would translate, the skills you've acquired would translate to a sit-down job and probably not to a light job. So I think that basically you are in pretty good shape as far as the grid rule. But to answer your question, it's not unskilled work, but it's low end, it's close to unskilled, but it's not quite there yet. Okay, Teresa had asked me before about some medical conditions, and 55 makes it easier because you are now clearly in grid rule territory. You can use, if you're limited to light work, and again, realize interview and date of onset are different things. So if your onset is 54, then the grid rules that you're going to deal with are going to be more in the sedentary range, where you've got to prove you're limited to sedentary work. But as of age 55, if you can do light work, you're still disabled, assuming no transferable skills and assuming a physical limitation. So it definitely helps to be over 50, and especially over 55. All right, naturally, Jessica, she's the one who has the myasthenia gravis and the POTS, and she's 45, and she was an HR manager for 23 years. So 45 is not as good as 50, but it's still, it's better than 35 or 25. And the fact you've got a long, consistent work history will help you, because, again, judges will generally tell you, and I've had judges say this, a person who's worked 23 years at the same type of job, they're not going to stop unless they really have to. So I think that works in your favor. Your age, you're getting close to the point where it starts to benefit you, but still 45 is considered to be a younger individual. You cannot use the grid rules, unfortunately, but you can certainly make a functional capacity argument. You're going to have to prove that because of the myasthenia gravis, as well as the POTS, the autonomic dysfunction, which obviously means, when you stand up, you get all, blood doesn't go to your head, and you faint and things like that. And you may have, I know lots of those people with POTS have Ehlers-Danlos, which means they've got hypermobility in the joint. Not sure if you do, but POTS can make it really hard to be alert at work because you're passing out. So, but you need to have a judge who understands that. You need to have a doctor who's willing to go on record to say that the level, that the degree of symptomology you have would be such that you would not be reliable at work. Okay. Support policies, not politicians. Hey, I agree with you there. Hi, I get SSI and SSDI. My SSDI has been on hold because I didn't turn in paperwork. Keep calling to say there's nobody assigned to my case. What should you do? If you cannot get anybody to respond, then you need to contact your senator or congressperson. And that person should be able to hopefully cut through the red tape. It is unacceptable, in my opinion, to say that there's nobody assigned to your case when you are not getting something that you've been approved for, assuming that's the case here. So, all right, Jen is my paralegal. Hello, Jen. And she's the person, if you're one of my clients, you will know Jen very well, because she's the one who is directing traffic in my office, and she's the traffic cop and does a really, really good job at it, and has a very good attitude, a very good sense of humor about it when sometimes we can be going a little crazy, but she keeps it all sane. Yahira Reyes, I'm a disability. I already want to know what an evaluation means after 5 years. If you get a notice that, you're going to be evaluated in 5 years, that really means you're not going to be evaluated probably at all. Or if you do, it'll be very random. But an evaluation means they're going to look at you to see whether you have shown medical improvement. They're going to first see have there's been any work associated with your Social Security number. If there has been, then they're going to raise the question, do you have capacity to work? And if not, they're going to say, has your condition improved? Now, if you were put at a 5-year review, that means you've probably got something fairly serious. You know, a 23-year-old with a bulging disc and diabetes, they may put it a 1-year review because they think, well, you know, that's a person who condition may improve. Or the judge may say in the decision, you know, we think that this case might improve. Therefore, Social Security should review it at 1 year. But a 5-year review is basically saying they don't really think there's much likely going to be much of an improvement here. Cancer-free, and I'm glad for that. 58 and 4 liters of oxygen are enough to get SSI and SSDI. No income and need help now. Where to go for money? Help now. I'm assuming you mean you're 58, you're on oxygen. You know, I would tell you to look at the listings. Let's take a look over there and let me see here. Let's go over to the listings. So to find the listings, I've got a website called metalisting.com. We're going to go to the listings themselves, and I'm going to look at the, let's see, we've got the respiratory system. You're not seeing that, so let me go ahead and stop sharing. Let's start again so we can see the way this works is that it has to be the specific page. So let's take a look at the respiratory system. So this is listing 3. And so they're looking at all these different things. And if you look at listing 3, you know, they talk about, you know, pulmonary function tests and spirometers and things like that to see, you know, how bad your pulmonary function is. So it is very possible you meet a listing. I'm not going to go through the listing, but, you know, if you are basically on oxygen, I suspect you're probably at listing level. So I would look at listing 3, and then what I would do is I would contact Social Security and say, I'm at listing level, I'm at listing, you know, just look down here. And again, I'm not going to tell you which one, but let's just say you meet listing 3.02. I'm at listing 3.02 because please evaluate me, please expedite the evaluation of my case. And that's what I would do. But, you know, as far as, you know, your question is, I need help now. The problem there is Social Security doesn't do anything fast. Now, again, this may be a case where, you know, you contact your congressperson and say, I have a dire need because I am about to be homeless, I have no income, I have no money, and I meet a listing. And, you know, maybe that helps a little bit. But, you know, Social Security is so backlogged and so backed up, even cases where people have, you know, conditions where they are, you know, on death's door, it's still 4, 5, 6 months. So there's no, I know that you need help now, but the problem is it's just, you know, that just doesn't really mean anything with Social Security. They're not going to give you help now, unfortunately. This is part of the problem we're dealing with Social Security. Okay, let's take a look up here, see where we were. Okay, we have a Facebook person, Cheryl, from Ohio. What is the SGA amount for 2024 receiving 1550? SGA is 1550. Gross income, that is gross income $1,550. You can earn before exceeding SGA. Now, if you have costs associated with allowing you to work, for example, if you have to have some sort of a special, you've got to rent a seat, you have to rent a monitor, you have medications, things like that, you can take that off the top. You know, I think also if you have, you know, if you're self-employed, you have a cost of doing business, take that off the top as well. But if you're just an employee, 1550 gross before taxes is SGA. And that is when the money, in general, when the money is received, not when you earn it. So if you earn it in May and you're paid in June, that counts towards the June numbers, the SGA numbers. So that is what SGA is in 2024. It will change in 2025. It was different in 2023. So 2024 is 1550. Rodney, is a 28% percentage whole person impairment for lumbar spine surgery. What are your chances? Now, when you talk about 28% impairment, that sounds like a workers' compensation number for a whole body impairment. So point one is that if you're getting workers' comp, then that offsets Social Security. So you got to be careful about that, number one. But number two is a 28% person. That is not really translated into Social Security terms because Social Security is focused on whether you can work or not. So that suggests a serious injury or serious impairment, but what you need is evidence to talk about why you would not be reliable. It's the same reason why when somebody says, I have a herniated disc, can I get on disability? I have type 1 diabetes, do I get on disability? I have chronic kidney disease stage 3, or can I get on disability? It depends. It really depends on how that condition impacts your functioning in a work environment. So the 28% doesn't really tell me anything. What does that mean in terms of your functionality? All right, SA says, do you believe notes from psychiatrists and other counselors from a 12-week intensive outpatient program for severe depression and anxiety are enough? How do I convey a job is too much? I think it would help. Now, again, if you go into disability and all you have is notes from a 12-week program, the question they're going to ask is, how do we know this is a condition that is going to last 12 consecutive months? So my experience has been that Social Security really prefers to see ongoing notes, from psychologists, psychiatrists. Now realize when you apply, it could take 10 months, it could take a year before you get approved. So, if you apply now, you've got this to start, but I would say having ongoing treatment from a psychiatrist or psychologist will make life a lot easier for you. But this is certainly a good start. And as far as conveying that the job is too much, take notes. What about the job is a problem? Is it the stress of it? Is it the interaction with other people? Is it the difficulty making changes in what you're doing? You need to have very much routine. I would try to document what the problem is, and what you might do is get a functional capacity form, and I'll show you what those look like here. There are a couple places you can get them, and let's just go over here, present, share screen. Here's one place. There's an attorney, Mike Merberg, who has a site. If you go to disabilityattorney.net, and you can go to or type in Mike Merberg, he has on his website a bunch of, he calls them RFC forms, residual functional capacity forms, but here is one from mental residual functional capacity. And again, I'm not going to, downloads it, but the point is that go to look at that and fill it out yourself. And again, that's not going to bind the judge or anything like that, but that gives you an idea what they're looking for. So that may be something to do to kind of get a sense of what the level of severity you need to be. Another place you can go is over here at the how to get on. Let's go over here, how to get on. And if you go to the simple residual functional capacity, and the website here is how to get on, just howtogeton.wordpress.com/sample residual functional capacity forms. You're just type into the search bar RFC, you'll get it. And there's a bunch of them here: mental, physical, mental form, I'll show you what this looks like. Let me go ahead and stop sharing, and then I can reshare. Probably a better way to do this, and I'll figure it out. But here is a mental RFC form. And I will tell you, in my practice, I try to customize these, but here is something that you can use. This is going to ask for a diagnosis under the Diagnosis Statistical Manual. So it's asking for something a little more technical. GAF is Global Assessment Functioning, and it's a number. Again, it's something a doctor or a psychologist is going to fill out. But you get into these things here about ability to remember locations, work-like procedures, ability to understand, remember short and simple instructions, ability to understand detailed instructions, carry out, et cetera, et cetera. So if you look at this, you will see these are the factors that Social Security is looking at that really impact your capacity for work. So again, what I would do would be to kind of fill this out on your own, do a self-assessment, and then maybe take it to your treating psychiatrist or psychologist and see if they will agree to sign off on it. that may help. But that's how. But I think that just having notes from a 12-week program is probably not going to be enough. Okay. Outside of recent changes, what 3 things do you think need to be changed about SSDI and SSDI to make it more fair? How can NOSCR help? And NOSCR is the National Organization of Social Security Claimants Reps. I did my first live stream from the NOSCR convention in Nashville about 6 weeks ago. How could Congress help? Well, the first and foremost, is they need to fund it. I mean, there's just not enough money. I mean, we had Commissioner O'Malley speak at the NOSCR seminar, and he basically said, the problem is we don't have enough money to hire the staff we need to process cases. So, there's not enough money to process the cases. They don't have the money to hire the right people, to train them. So I think that first and foremost, this is a financial problem that Congress has not allocated enough money. I think the second thing that they could do, and I think NOSCR is something on their list, is to reenact the treating source rule, which basically says that an opinion from your treating source, a longtime treating doctor, should be given controlling weight. Right now, they've eliminated that, so a judge can deny your case based on a one-time consultative evaluation, which to me is absolutely ridiculous. But that's what they do. So I think that would be something, reinstate the treating source rule. I think another thing they could do is eliminate the 5-month waiting period. Why do you have to wait 5 months before you start getting benefits? It's just, causing more financial hardship. And I think a really big thing they could do Congress could do would be to make Medicare start immediately when you're found disabled. Right now, you become eligible for Medicare 24 months after your first payment. So realize there's a 5-month waiting period, then you start getting paid. So let's say that you applied and you were approved in July 15th of 2024, a couple of days ago. Well, you don't get paid. You don't get paid for July. It's a partial month. You're going to pay for August, September, October, November, December. You start getting paid in January of 25. So that means you don't get Medicare until February of 27. So now we're looking at, well over 2 years before you get Medicare. In the meantime, you can't work. You're on disability. But you can't go to the doctor because you have no Medicare. And then if they want to review you, they say, well, you haven't gone to the doctor. Yeah, well, I have no insurance. You didn't make me eligible for Medicare. By the way, SSI and Medicaid become available immediately. Now, I realize this is a money issue, cost-saving issue, but the problem is you're putting people in a situation where they're disabled. They obviously have a medical problem that needs to be treated, but they have no source of insurance, no Medicare. So I think that Congress could change that. So those are a few things that if I was put in charge, that's what I would do. And I know Commissioner O'Malley would like to do these things. But the problem is, he's a political appointee. So if the current administration loses in November, then he'll be out. Even if they win, it's possible he may be moved up. He's actually doing, I think, a really good job. And so they'll maybe bump him up to something else. He's been a presidential candidate before and probably will be again. So, right now is kind of a really interesting time because we've got a commissioner who really gives a darn about Social Security, is really trying to make improvements and really cares about the people, I think, that are, applying for disability benefits, as well as the people who are collecting retirement benefits. But we may be, unfortunately, in a very short honeymoon period, and that, in January, February, this is all going to go away. We're going to have either a more hostile commissioner, or even if it's a Democrat, even if Biden wins, we may have another commissioner who doesn't have the same, approach as Commissioner O'Malley. So the point is, unfortunately, I don't expect any major changes anytime soon. But and especially if the Congress is divided as it is, I don't see that there's going to be any changes. Bottom line is, people pursuing disability have no lobby. There is no, there's no money being paid to them by lobbyists. I mean, NOSCR has a lobbyist, but it's not like the AARP is going to go to bat for people on disability. It's not like there's an NRA there. So unfortunately, people on disability are the redheaded stepchild, as it were, in American politics. How could the president help? Well, again, I think part of it would be to propose a budget that would fund Social Security, and again, to support the current commissioner in his desire to modernize and to make it more efficient and more fair. But again, presidents, are concerned. They have a lot of constituents. They're focused a lot on making deals work, and Social Security is just, people on disability are just not a major political force. There's no lobby. It's not like if they screw over people who are on disability, it's not like you're going to have anybody raise a big stink. I mean, the AARP is the closest thing to a lobby, but they're focused on retirement benefits, a little bit on disability, but they're just not going to go to bat for it. So we're just going to have to deal with what we got to deal with. And again, we've gotten some positive things through in the last few months, and hopefully that doesn't get reversed. There's been some talk about making it harder to get on disability. So who knows, but hopefully not. Calvin, if you applied for SSD in June of 23, but they're looking at your 15-year job history, 5 years, they're looking at 5 years. As of June 26th, 27th of this year, everything switched over to 5 years, so it is now effective for every case that's decided after June 26th, whatever. There'll be a 5-year look back. In fact, I had a hearing a couple of days ago, and the judge noted that this is a 5-year look back now, and we're all getting used to it. That benefits you as a claimant, by the way, because it means that a judge is going to look at the last 5 years of what you did. So work you did 10 years ago, any transferable skills you might have had don't apply. Whether you can go back to past work, it doesn't count as past work, because they realize that, and this is again something that the commissioner, I think, has gotten through, that work you did 10 years ago is not particularly relevant in this 2024, because things change so much. So this benefits us as disability claimants and lawyers to have a 5-year look back as opposed to 15-year look back, but it is now enforced for every case going forward. Do I have to get a lawyer? Will that expedite? I think you are the one, support policies, who have a your case has been on hold because you didn't turn in paperwork. Should you get a lawyer? Maybe. I mean, again, I think that, look, I'm a lawyer. I do this for a living. So obviously I think lawyers have value, but if it's simply a matter of getting paperwork pushed through, I would probably tell you to start with going to your congressperson, because honestly, if somebody called me and they have a problem with paperwork being stuck, I'm going to say, call your congressperson. There's not much I can do about it. This is really more something that your senator's office can do. So that's what I would do first. And then once it gets unstuck, if you're having trouble with the substantive part of getting approved, then that would make sense to get a lawyer. You say potato, I say potato. Okay, there was a song, I think in the 30s or 40s about that, 1930s and 40s. We're getting close to the 30s and 40s in the 2000s, but that is an old song, I believe. We have Boat Snows Barbecue. Hello from Oklahoma. I understand, now you tell me if I'm wrong, that barbecue in Oklahoma is supposed to be better than barbecue in Kansas City and in Texas. Now, I could be starting a big fight here, but I've read that the barbecue in Oklahoma is really, really good. You tell me, but that is just what I've heard. Can you pin your email address? Well, again, here it is down here. If you just go to bit.ly/contactjonathan3, that will come through to me, and I know it's coming from this. My direct email address is ssdanswers, ssdanswers123@gmail.com. But I'd rather use this form. That way I can track all the emails coming through this form. But just say that, Donna, just say, I'm Donna from the live stream, and I'll know who you are. But use bit.ly/contactjonathan with a capital C, a capital J, contact Jonathan 3. That way I'll know where it's coming from. And Garrett will tell you, as Garrett is works with me in my practice management and marketing. Here is how to get a case evaluation. So again, he's got that. I've got it written below there as well. Okay, that's the form I know I do about my TBI. Are you talking about the continuing disability review form? Yeah, I mean, this is, it's SSA, the one from, I think the long form is SSA 454, and the short form is SSA 455. So, I would, get, you don't fill it out until they ask you to do it. But if you want to look at it, you can search for it, or just go to my website, continuingdisabilityreview.com, I've actually got a website called continuingdisabilityreview.com. I don't do much on it, quite frankly, but I've got one out there. I'll probably build this out a little bit later on. But if you go there, you'll see links to the short form and long form. So, okay, why is SSDI and how does back pay 17 months from date of application? Okay, and I realize, Christina, this is it gets a little technical, but you can get paid up to 1 year prior to your date of application. So let's say that you say, let's say today is what, July 17th, I think, is that right? July 17th of 2024. Okay. So let's say you say, you filed today and say, I became disabled July 17th of 2023. So that's 1 year prior. Well, if you're approved as of July 17th of 2023, you will not get paid for the rest of July because it's a partial month. You won't get paid for August, September, October, November, December. You start getting paid SSDI in January of 24. That's when the past due benefits will kick in. Okay. But let's say that you say, instead of becoming disabled in July of 23, became disabled in January of 2023. All right. You're applying again today, July 17th of 2024. You say I became disabled in January. So the 5-month waiting period runs January, February, March, April, May, and June would be the first date of eligibility. You applied in July of 24, so you can only go back a year. So that means the 5-month waiting period ran before you first became eligible for payment. So if I have to choose an onset date, I'm going to choose an onset date that is 17 to 18 months prior to the date of application. That maxes out the money, if that makes any sense, because you're using up your 5-month waiting period before you're even eligible for payment. And then when you become eligible for payment, you get paid right then, as opposed to that's making the 5 months start right then. That's why I say 17 to 18 months. Hope that makes sense for you. Okay. 58, age 50, oxygen, arthritis, real bad, severe COPD, emphysema, good chance. Does it have to take the whole 200 and some? I don't know what that means, the whole 200. But I think you have a good case. Yeah, I think if you have emphysema and severe COPD, as well as some arthritis, you could make a grid rule argument using the light grid rules that you wouldn't be able to do light work, and that the pain as well as the breathing issues would interfere with any transferability of skills. Or you could argue functional capacity, that your capacity to function reliably at a job has been so eroded by the combined effect of your COPD, emphysema, and arthritis. You could maybe meet a listing. So yes, I think you do have a very good argument for disability there. Hopefully one that would get approved early, but you cannot, there's just no way to guarantee you're going to get approved early. They just, they're going to do it if they want to do it. Sherry Mooneyhan. Sherry, your name sounds very familiar. Anyway, good evening. How hard is it to get a DLI changed? Well, DLI is a mathematical calculation. What that stands for is date last insured. So if your date last insured, let's say, and it's based on your earnings. So, when you work and pay into the system, it's approximately, what is it? Like if you earn like $7,000, $7,500 a year, that will get you all 4 credits. So every year, let me see if I can get you the number here, so we can see that. Okay, stand by here. Okay, so earnings credits here. All right, I'm going to share my screen here so you can see this. All right, let me make it a little bit bigger here. Okay, so basically to get 1 credit in 2024, you need $1,730 of earnings. And multiply that times 4, whatever that would be, 7,000 something dollars. I think it is $6,920, maybe is it? I think I come up with. But anyway, that gets you your credits. So you've got to have, most of the time, 20 credits the last 40 quarters or 5 out of 10 years. So if they're telling you your date last insured was, September of 2021, the only way to change that would be to work either A, was there a mistake made? And there's a form you can use to correct your earnings record. They made a mistake and didn't count earnings that you had. That you can prove that you actually paid taxes. They could change it that way, or you could go back to work. And sometimes I tell people, I talked to a guy about this earlier this year. I said to him, the problem is you're short 1 or 2 quarters. So go back to work and earn $7,000, in 24. Just, figure out a way to do that. That gets you enough quarters so that you are now insured. So the only way to really change the DLI would be to find more quarters based on earnings that were not credited to your account. And if you want to go to your My Social Security Statement, ssa.gov/my account, that will show you the credits that you've got. So if you're seeing things are missing, then you can file a form to correct that. Just look up the form to correct earnings record, or go back to work and earn $5,000, $7,000, bust it and just do what you got to do. And that gets you enough credits to get your date less insured changed. But that's the only way to really do it. Christina says, Garrett, you've got a fan here. Okay, very nice. Garrett is here again. Garrett is ruthless. He will just continue to tell you to file for a free case evaluation. But that's why Garrett gets the big bucks. Okay. All right, hits for life. Sounds like you've been hit a few times there, hits for life. I suffer from chronic radiculopathy. SSDI case was sent to see the judge for the 3rd time at the state. I saw their medical doctor. I'm waiting to see the judge. Again, the point here is, radiculopathy is a diagnosis. How severe is the radiculopathy? Do you have numbness in your hands and your feet? How does it interfere with the ability to work? You don't win because of a herniated disc or radiculopathy. You win because the underlying condition is so severe that you simply would not be very reliable at a job. So that is really the way you win. So you don't win just on the diagnosis there. Okay, VV20VV, that's an interesting handle. Okay, it's the old child support question here. Let's see. If I owe arrearages for child support, will Social Security Lori be able to get their back pay out of the SSD back pay owed to me, even though child support will take all my back pay? I think the answer is yes. This question came up on the NOSCR listserv, and I believe that the attorney would get paid, but I would probably want to check on that. But according to my colleagues at NOSCR, the child support arrears just come out of your portion, but the attorney would get paid. That's my understanding, but I could be wrong. Okay, so I think you're talking about this case, the Loper case involved the SEC. I don't think it was SEC, but I could be wrong. I thought it was a different agency, but I don't know. Again, it's a fisherman case, so I don't think the SEC would be the appropriate thing. But again, it's a different. I don't really know. I mean, this is constitutional law, which, by the way, was one of the most interesting courses I took in law school. Fascinating stuff. But constitutional law is in the ivory tower. They're looking at doctrines. They're looking at very, very big picture law. Disability work is in the trenches. I'm trying to get people on benefits. Constitutional law, you're looking at very, very big ideas. And it's really, really interesting stuff. And con law was really interesting to me because you just really understand, reading the newspaper, you understand why things are done this way. Even if you don't agree with them, you understand the logic of what the courts are doing, because you may see a case where somebody is a conviction's overturned if somebody's clearly guilty because the sheriff or the police officer didn't read the person their rights. Well, a guilty person gets off. Well, why is that? Because if you allow the police in this particular situation to, to not adhere to the constitutional requirements of the Fourth Amendment, then, we have chaos. So, the thought is you'd rather have, a guilty person go free, but protect the rights of everybody else. Because believe me, if you're in a situation where, you're pulled over or you're arrested, you want the police to do all the rules right, not to coerce confessions, not to beat you until you agree to say what they want you to say. And that's what constitutional law talks about. There are a lot of these cases obviously involve situations where you have a person who's guilty, but the police, used coercion to get a confession, or they sleep deprived him or tortured or whatever it may be. And, the courts don't allow that. And so that would be the reason for reversal. And reading a newspaper as a, regular person, you're like, well, that's ridiculous. Even though the police did wrong, why is this person getting out? Well, because it's a constitutional procedure. So that's what con law is really about. And, you read the newspaper differently because you realize that the courts are making decisions not about a particular situation, but about the big picture and how things ought to be. Okay. That's the old case. There's a new case that changed. Well, the new case that changed Chevron, I think, was the Loper case, if I'm not mistaken. That is the Chevron case was a 1984 case, and the case that shut it down was Loper Bright Enterprises versus Raimondo and Rentless Inc. versus Department of Commerce. So that's the case that was done. That shut down or challenged Chevron. But realize I am, I'm not the person to come to about con law issues as much as I find it interesting. I don't keep up with it. And again, there are a lot of people who are a lot smarter than me that keep up with it. And it's really very, very interesting stuff. So, okay. Let me see here. I think that my... I'm not mistaken, my Instagram has gone quiet. Let me see if I can restart that. Please bear with me while I do that. Let me see here. So anyway, we'll see if it works. I don't think Instagram is going to work now. For some reason, they only let you go for an hour, is my understanding on Instagram. So it's a different platform. I don't have a lot of Instagram followers, but I'm just I'm not going to go through. I'm not going to spend a lot of time on this, but because it doesn't let me do this. All right, so I'm not going to worry about that. Okay, so we'll just forget Instagram for now. All right, because it only worked for an hour. Okay, Nomad says, I had a phone hearing on 3/18/24. Just yesterday, the judge started the decision-making process. It takes another 30, 60 days. We're approved. How much longer will it be before you get paid? Okay, if and this is not terribly unusual, but if you have been waiting for, already since March, and the judge, approves the case in 30 to 60 days, it'll be another 30 days before you see any money after the date. I would say 2 weeks to a month before you see the first dollar out of Social Security. Okay, I think you got cut off there. How to remand an old SSDI case after denial. I'm not sure if I understand, Arthur, what that means. I'm sorry, but you can maybe explain further. Hemiparesis, hypothyroidism, TBI, and epilepsy, odds of renewal. Again, you don't win on a diagnosis, but those are pretty serious things. I still come back to, what does it mean? What does it mean in terms of your functioning in a work environment? I want to know. Eric, thank you for hiring us, and I'm looking forward to victory as well. Absolutely. We take our cases, we work them real hard, and we're going to do everything we can to get you approved. Okay. EROCC, we'll say, is 38 years of age. He's at Reconsideration, workers' comp IME, says no lifting, pushing, pulling greater than 5 pounds, no repetitive bending, twisting. Do you have a chance? Yes. I think that IME will help you, but I would also tell you, that if you're getting comp benefits, that's going to offset your Social Security. So, you might want to talk to your lawyer, your comp lawyer and or Social Security lawyer about when you are going to be able to pursue disability, because you may win disability but see no money because you're getting comp. And when you settle, you want to make sure your settlement statement has a language in there that basically puts you, basically pays you over your expected lifespan. I would also tell you that comp cases many times have doctors' records from unsympathetic doctors. So, there may be some records that support you, the IME, independent medical exam, and some that do not support you. So you want to look at your record as a whole, but having a good medical IME certainly helps. Okay, Jim, I have an ALJ hearing in November, approval at 47%. When do you start prepping your client? I would say, first of all, 47% is about average. I think that, what we do in our office is when we get a hearing notice, my paralegals, Jen and my other paralegals, will start updating the medical record, getting all that done. So if you want to call that prepping it, we're starting to get the medical record updated because we've got to do that. We make sure all the forms are filled out, the medication form, the past work form, the recent medical treatment form, all that's done. I have a medical doctor on staff as a paralegal in my office. She will review the medical record and kind of give me a summary of it. Then I review the medical record, and then I call my client. It may be a couple of weeks. Sometimes it's a week. It just depends on, I'm working on a brief. There's there's a lot of us working on it. So I would say that the real prep starts about 6 weeks to 2 months out. And then the more, as it gets closer to the hearing, that's when I get more involved in it. But I think that November is still a long ways away. So I would say your lawyer should be prepping you, starting the process now if you have a November date, but probably you won't really do a pre-hearing until sometime in maybe mid-October would be my guess. What about overpayments? Okay, overpayments. Give me a second here. Overpayments are difficult issue because Social Security has decided that you were not disabled and you continue to get payment. Maybe you went over your trial work period months, then you went over SGA and you got an overpay status. There is a form you can fill out asking them to waive overpayment. The form basically says, let me see if I can get you the number of that form. Overpayment waiver form. It is form 632BK. And basically you are asking Social Security to waive the overpayment because of some error that they made, a mistake, that didn't tell you something, or that you can't pay it back. It's not fair. I don't deal with this a lot because I don't really deal with overpayments very much. My understanding and experience has been that it's pretty rare to get them to just waive it. Now, you can ask for reconsideration if they deny your request for waiver. You can ask for reconsideration. If they deny that, you can ask for a hearing and go in front of a judge and basically say, it wasn't my fault, they didn't tell me something, or there's no way I can pay it back. I don't think judges are all that sympathetic to that. What I generally tell people is give a long look at bankruptcy. You can wipe this out in bankruptcy, and that's sometimes the fastest, easiest way to do it. Just use bankruptcy to wipe it out. But otherwise, overpayments, the problem, I will tell you, just to continue on that, is you get a lawyer, you got to pay the lawyer out of pocket. And you get a lawyer who's going to do a recon, do a hearing, $3,000 or $4,000, and the odds of winning are low. It just doesn't make a lot of sense to me. Okay, DLK, MDK says rheumatoid arthritis, osteoarthritis, Raynaud's, cervical spinal stenosis, knee replacement, 20 years in a present job. Again, all these things suggest a serious problem, but you don't win based on having cervical stenosis. You win on cervical stenosis that makes it impossible for you to use your arms to lift more than 5 pounds. You've got to be, it's got to be very specific, and it's got to create specific limitations. Diagnosis doesn't win your case. It just doesn't do it. Got to have specific problems. Angelita, if I won my case very good question, Angelita. If I won my SSN SSDI case in federal district court, why are they remanding the case? Okay, because what's happening is you went to district court, you lost it at your hearing, I'm assuming, went to the appeals council rubber stamped the ALJ, went to district court, the district court said no, they made a mistake. The district court, in most cases, 95% of the time, 98% of the time, they're not going to just say, yes, this should be paid. They're going to send the case back to the judge with instructions about what to do right. The judge did not analyze, did not consider your subjective complaints of pain. The judge did not explain why he or she disregarded an opinion from a doctor. The judge did not properly make a hypothetical question to the vocational witness. So they're going to send it back and say to the judge, do this right. Now, some judges get the picture, like you just got remanded, approve the case and just be done with it. Other judges are like, I don't care what the damn district court says. I'm going to look at this case the way I want to look at it and, blank them. So it just depends, but it's not going to generally be approved at the appeals council or district court. It's going to be sent back, usually to the same judge who denied you the first time, which makes zero sense to me. And maybe that's something that that now that we've got this Chevron case, it's been eliminated. Maybe that's one of the things that the deference of Social Security, their policy of sending it back to the same judge, maybe that changes. Maybe that would be something you can contest. Teresa, I've worked 2 jobs in the last 17 years. And again, I think that helps you. It goes to your credibility. It shows you're a hardworking person. And judges, that makes a big difference to them. They see a person with a long work history who's been consistent and continues to work, despite, having some medical problems. That can make a difference. Judges do like that. Thank you. You are very welcome. My issue is, Jamie says, I sent the form in late, took me 3 months later. I'm not sure what form you sent in late, but normally if you send a form in late, let's say a recon appeal or a hearing appeal, you can ask them to, consider good cause for, considering that late filed form. It doesn't always work, but usually if it's 3 or 4 months late or less, they'll let you off the hook. 60 days is the deadline for most things in Social Security. That's just not a lot of time. Not a lot of time at all. Thank you. Well, my pleasure. I'm glad to help any way I can. And I like to take everybody reaches out to me. I like to take everybody's case. Can't do it because frankly, some cases I know are just probably not going to win, and I'm not going to waste your time, and I'm not going to tell you something that I think a case is winnable if it's not. You do this. I've been doing this for 35 years. I kind of know. But we try to take every case we can, and even some of the more difficult ones, because I can tell people are really suffering, and if I can help, I will. Okay, vocational experts only asked 4 questions, and 3 went in your favor. The judge also agreed to my onset date back to me or back pay. Would he agree with that if he's going to deny you? No. If the judge is going to amend the onset date to give you more back pay, he's not going to deny you. It's not going to happen. So I think in that situation, you are probably in pretty good situation there. Okay, let's see what else we got going on here. Okay, so after 6 months, they can make a decision, appeal to cancel. I'm not sure, Jamie, what you're saying. After 6 months, they can make a decision to appeal or deny, cancel my monthly SSI. Jamie, I need more details. I don't know what you're asking me. I'm sorry. 14.07 listing. Let's see what 14.07 is. That is an immune system case. It is HIV and not HIV, immune system disorder that is not HIV, and it's basically an infection. It's a hard listing to me. I'm looking at 1407 now. It is a hard listing. I've probably had them over the years. I don't have one right now, but I think this is one where you need an immunologist to look at it and say that you meet this listing. but it is a difficult one because immune system disorders, the things they look for, sepsis, meningitis, pneumonia, septic arthritis, endocarditis, stem cell transplantation. It's got to be a really, really, severe level of infection to win that listing. So again, don't limit yourself to listing. Look at the grid rules, look at functional capacity as well. Rheumatoid arthritis, they're hard to get approved. I'm 52 years old, 20 years in the job, at a knee replacement, osteoarthritis, cervical spinal stenosis, and remands. Rheumatoid arthritis is stronger in general, and again, every case is different, but it's a stronger argument, I find, than osteoarthritis. Everybody gets osteoarthritis. You get older, and you're going to have some osteoarthritis. Rheumatoid arthritis is a autoimmune inflammatory process. You're going to see it. Your knuckles are going to be enlarged. It can be very painful. It can be, there can be other symptoms that go along with it. So I think that inherently, rheumatoid arthritis is more serious than osteoarthritis. So, it's a little bit easier to get approved, but again, it's a matter of degree. What is the degree of impairment? What's the degree of impairment? Okay. And by the way, let me throw this out at everybody, because I know there's a lot of people who've been, and I love the questions. If you're interested and if you don't mind doing this, I want to try something different with the YouTube channel. Make me a recording. Record yourself on video asking a question, and just email it to me, ssdanswers123@gmail, and I'm going to use that to make a video. So again, if like this question here, I suffer from chronic migraines, lumbar radiculopathy, anxiety. Record that. Make me a recording and just send it to me by email, and I'm happy to, or email me and I'll give you a cell phone to send it to, and I'll just put it in the video and answer it. But that, I think, would be an interesting way to do it. That way I'm answering questions from people, but if I have you on video asking the question, and then I can answer it, I think that would be kind of a compelling thing. So that's something I just want to try, but if you don't mind, anybody wants to do it, just ssdanswers123@gmail. Just make a video asking me a question. I'll take the video, add it to, answer the video, or answer your question on video, put your question in there, and that'll be a video for me to put on the YouTube channel. So I just want to I thought about doing that. That's something that I think would be kind of an interesting change from what I'm normally doing. So if anybody's interested in helping out, please do it. That would be great. Okay. Hits for life. I suffer from chronic migraines, lumbar radiculopathy, and anxiety after 7 years. SSDI case was sent back to see the judge for the third time, saw their medical doctor again. 7 years suggests it's been remanded. Anytime migraines are hard because you can't do an MRI of them. They just, it's based on your reporting. It's based on your neurologist or migraine doctor. Radiculopathy. I think it's going to be a matter of getting medical support, and they're going to look at the medications you're on, the treatments you're on, to determine whether or not it appears to be severe enough where this would be disabling. But yeah, those are hard cases. They are hard cases, and they make it hard for cases where there's a subjective element to get approved. Okay, good question. Live your life. When it takes a longer time, like say with the judge, does it mean a better chance of getting disability? No, it does not mean that. It just means that the judge is backlogged, that the writers are backlogged, so it doesn't mean anything. It could be three. I just got a hearing decision today in July from a case that was tried in March, got approved. But I also get one. I also have ones that were approved. I get a decision in 2 weeks. It's just, there's no rhyme or reason to it. What do you do? Very good question. When you lost your case, but it still doesn't change, you're being disabled. Now, 2 more herniated discs with spinal stenosis. If you'd work, how long would you have to work before reapplying? You don't have to. Again, this is assuming you're still insured. So you still have the insured status thing going on. So that's not a problem. If something has changed, you've got new herniated discs, if you've changed your age category, you could reapply right away. I generally tell people don't reapply right away unless something has changed. Ideally, an age category went from 49 to 50 or 54 to 55. Now the grid rules can come into play. But if you have a new injury, a new diagnosis, that can be grounds to do it. You're still going to have to convince the judge that things have gotten much more serious. But, the positive is if the judge found that you were limited to, let's say, sedentary work, and you found you could do sedentary work, and now that's sort of already been decided, so you don't have to go back and reinvent that wheel. But I think having a new diagnosis, new herniated discs with stenosis, that would support a new application, assuming you still have insured status. But if you don't have insured status, you got to go back to work long enough to get your date less insured into the future. Okay, I see there's a change coming so for SSI as far as gets to benefits to cover rent. If I understand it correctly, could you elaborate on that? Let me just say this. I know that they changed the rules for SSI in terms of in-kind support, which is what you're talking about. Let me see if I can find that. In-kind support, SSI change. Under the final rule, beginning September 30th of 2024, Social Security will no longer include food in in-kind support. So if you're getting support for food, let's say your family members are buying you groceries, that does not offset it. I'm not aware of any change in terms of rent. I could be wrong. So I don't deal with that part of it very much. I don't really see a lot of SSI. Let me see what I can find out. This is something maybe Greg Brinkley would know more about, because this is something that when the SSI people do their income and resource interview, there are rules that cover, what would be used to offset in-kind support rules. Let me see if there's anything here. I'm just looking real quick here. Change one would be, again, food. That's been admitted. There's one that says here, where landlords charging rent. Okay, so if there is a rental subsidy, again, this is getting kind of technical. I'm not going to sit there and read it while everybody's watching me read, but there apparently is something. If you go to, there's a website here, and I'll put the link in the comments, because again, this is beyond what I have time to do, but I'm just going to put the link in the comments. So if you want to look at this talks about the question you're asking about with SSI. So I just, again, I'm focused on getting people on benefits. I don't deal that much with the SSI income and resource type of thing. And honestly, most of my cases, I would say, 98% of my cases are SSDI. I just don't see a lot of SSI cases. And part is because the offsets make it hard to get paid, quite frankly. Recommendations for additional info to gather before hearing. A 40-year-old male, back pain, fusion, spinal cord stem, had to pace with small steps and walker, constant 6+ pain. Okay, I would say do a pain diary. Keep it, just get a calendar, do a pain diary talking about your level of pain. If there is a third person who has observed you in pain, it could be a relative or friend, have them fill out a third person, disability report. There's a form, I don't remember the number of it, but a third person report. Let me see if I can find that for you. Third person disability reports, third party. That is form 3380. So you could ask somebody to fill out a form 3380. They could also just write a letter to the judge saying, this is what I've observed about Carly's back pain and why I believe that she's in pain. And if you get 3 or 4 of those, I'm not going to say that's going to win your case, but having, especially from non-relatives, people that know you, former coworkers, somebody who's known you for a long time, it can make a difference. And former coworkers are great because they don't have a dog in the fight, and they're talking about what Social Security is focused on is your work capacity. But even statements from friends and relatives can make a difference. But I think, a third party, the form 3380 could help. I think a pain diary could help. I think a medication side effects diary could help. And I think, again, statements from people that have observed you, that could help a little bit as well. But going back to Carly's question, medical records are far more important than any of that. Having strong medical records, maybe a statement on the listing, or functional capacity form, that's going to be a lot more important than a third-party form. Latoya, make sure you're going to tell all your doctor's visits, test labs, get functional chiropractic. All right, chiropractic is not going to help you. Unfortunately, Latoya, chiropractic is not considered an acceptable medical support source. So getting a functional capacity form from your chiropractor will not move the meter at all with Social Security. Treatment notes will show that you went to the chiropractor, but the chiropractor's diagnosis and functional capacity evaluation will mean nothing to Social Security. So you want to make sure you get all your records in true, but if you're going to get an FCE form, chiropractor is not going to help you. Just the reality of it. I'm sorry, it's not going to help you. Let's see. T-Cash says, SSA said I was approved medically, waiting for the non-medical approval in 3 months. Contacted local office. Okay, I got a case just like this where I got a client who is not very happy, and she's like, "Where's my money?" And I call the district office, like, "Where's my client's money?" Well, we're still doing our review, and the problem is that what they're looking at is to see whether you've had any earnings after your onset date. And they've got to just go through their checklist to confirm you have not gone back to work or that nothing has changed. It's ridiculous that it is delaying things. That's like ridiculous in my client's case, but that is what they're going to do. So you can't, again, the only thing you could possibly do to speed it up would be to contact your congressperson, your senator. It's having minor children. Yes, if you're approved, your minor children will be eligible for what are called auxiliary benefits. That can be as much as 25% of what you get in addition to what you get. In other words, your children get the 25% of your benefit. Let's say your benefit amount is $1,000. They'll get $250. It doesn't take away from what you get, but they'll get it in addition to what you get. But your minor children, you'll get the auxiliary benefits, which is helpful. That can be really, really good. DD, I'm waiting my initial decision, hoping to have one from now, but I'm at best 6-month mark, 58 cervical, spinal stem, Parkinson's, and more. I think you have a good case. I think that, Parkinson's, I've had very good results with Parkinson's cases because judges realize and Social Security realizes that it does not go away and that people fight it, obviously, but they, the symptoms can be both cognitive as well as physical, and that can be very, very debilitating. Again, at 6 months, I would probably tell you to reach out to your U.S. senator or representative, because I think that that's been a long time, and I think now it's time to possibly go ahead and do that. But I think on the face of it, probably not a bad situation in terms of having a good case there. K. Wolf, although again, realize you don't win because you have Parkinson's, but Parkinson's symptoms are usually debilitating. K. Wolf, denied an initial try, denied at recon, waiting for ALJ. The new ruling, go back 5 years. Yes, that is correct. So your case will be under the 5-year rule, so they're only going to look at the work you did in the last 5 years, not the work you did 10 years ago or 15 years ago. And as I mentioned before, that helps you because it means there's less things that they could say you can do, which is good. Patty is 65. I just had my birthday, first week of July. Well, happy birthday. My birthday was the second week in July. I'm on SSDI. Will ever get regular Social Security? You will get, yes. If full retirement is 66, they'll convert it automatically. If it's 65, they'll convert it automatically. So I'm guessing it'll be 66 because I think that, I could be wrong, but whatever it is, look up there's a place on Social Security website where you can look it up. It will tell you when based on your date of birth, when your full retirement is, but they will automatically convert it. You don't have to do anything. Rodney, 45 years old, worked 10 years as an auto worker, diagnosed with bilateral hip dysplasia, osteoarthritis in both hips, need right hip replaced, herniated disc, and doctor diagnosed with major depressive. So the positive is you've got some significant medical problems. You need a hip replacement. Those are all really, really strong things, strong parts for your case. 45 is a younger individual, so there's a balance there. I think on balance, I would say if I think it's probably a pretty good case, pretty good argument for disability based on the degree. So in other words, when I'm looking at a case, and I got a 45-year-old with this level of impairment, I would be more inclined to take that versus a 45-year-old with something, less significant. Again, I'm going to look at the records, but this is the level of impairment that would cause me, just me, to say I'm going to take a case for a 45-year-old or a 35-year-old. It's significant problems, assuming the medical record supports significant limitations. Maybe O'Malley, well, he did run for president at one point, but this is not the YouTube for me to pen on presidential politics. No, it is not. We could have a very robust debate, I'm sure, about presidential politics. My personal thought is we've got, well, I'll just leave it at that. It's interesting, two interesting choices, let's just say that. But we're going to, and obviously, with what happened this weekend, it's kind of interesting to see how this is going to all play out. But, whoever wins, let's put it this way, I think whoever wins, the Republic will survive. We will survive. Everybody's talking doom and gloom. This one says if Biden wins, the world's coming to an end. If Trump wins, the world's coming to an end. Not coming to an end. We're going to survive. Will Social Security be on the front burner for either one of them? No. Will it be less of a priority for Trump? Probably. Is this, will Biden keep O'Malley? He will probably keep O'Malley, but O'Malley may be pushed up into a cabinet level position that is more public. Who knows? I think I will say this after living, for many decades. One thing you can say for certain is that you don't know what's going to happen. I mean, again, going back to Supreme Court, we talked about it a little bit. You look at some of the justices over the years that were appointed by Republicans that, became like Earl Warren. The Warren Court was the most liberal, activist Supreme Court we've ever had, appointed by Eisenhower, I think, was a Republican. So, he thought Earl Warren was a very conservative vote. We've had others that are quote unquote liberal that, turn more conservative. You just don't know. You just don't know what's going to happen. And I think that, but we're going to survive. I think we will survive either way. Vic, hello, Surf. My onset is established in 2020. I'll get back pay. It depends on when you applied. Because if you applied in 23, you'll get back pay 1 year going backwards. You won't go back to 20. If you applied in 2021, you could get back to 2020. So it depends on when you applied. You can go back 1 year from date of application. Makes sense. Well, that's good because hopefully what I'm telling you does make sense. That's the, I'm not making this up. I will say most of the stuff is coming from what I've learned over the years. I'm trying to share with you. Hearing request has arrived. The appeal document grid rule 62 prognosis. Can I get approved before they? Okay, a hearing request. Yes, you can file a request for what is called on the record decision. And the on-the-record decision could get you approved early. I've had a few, I'll tell you, pardon me, that, judges are really busy, and I do a brief in almost all my cases, and, sometimes they'll approve it on the record, but even when I get the brief in a month in advance, they still a lot of times go to the hearing. So I'm seeing less on-the-record decisions from the NUSCR listserv, fewer and fewer. Not very likely, but there's no reason not to try it. I think personally, writing a brief and a request for on the record helps me solidify my argument, understand better what I'm trying to say. So it makes me more effective at a hearing. There's Garrett again. I retained Stephanie. Stephanie, okay, great. Stephanie, I was hoping to get Stephanie on tonight, but she had other plans, but we're going to get her on in the future. Stephanie is another disability attorney in Ohio. We've become pretty good friends over just through, virtual. She hosts a roundtable for disability attorneys every month on LinkedIn, and it's a very valuable resource for me because it's a chance to kind of run ideas past people. And the nice thing about disability community is that most of the attorneys are pretty friendly, willing to help. The NOSCR listserv has been a great resource for me. There's a lot of people on there. What do you know about this judge? Like I got a hearing coming up on Friday with the judge I'd never been in front of before. I put something out there. What do you know about this judge? And somebody responded, he's a nice guy. He likes this. It's just helpful. So I think most lawyers are pretty helpful. Stephanie is very sharp, and she's, does really takes her cases real seriously. She's a solo and does a really good job. So you are in good hands with her. Okay, and Garrett tells you that using the contact form, which again is bit.ly is like a link shortener, contact Jonathan with capital C, capital J 3. That is the best way to reach me. That is true. And that also tells me where you're coming from. So that's why I like that. Okay, I emailed all of them. I'm assuming you're talking about your reps. Tried calling SSA office, enters the government slowly. Yes, it moves really slowly. Not just slowly, it moves glacially slowly. And it's unfortunate that people suffer because of that. People die. I think they were told us at NOSCR that 30,000 people a year are dying waiting for disability decisions. That's insane. 30,000 people, but that's what they're telling me. I think that was it. 30,000 people. I applied at 54, says Cass. Approved at 55 based on the grid rules. Lost the back pay. Charged under the 5-month waiting period, a 13-month. If you change your onset date to the 55th birthday, and the 5-month waiting period runs as of the time you change your onset date to, you're going to lose a lot of past due benefits. Yes, that is. But on the positive side, you have ongoing future benefits, and that's a tough call sometimes to make. But that is what you got to sometimes decide what you want to do. So will I lose work credits for SSD because they aren't going to go back as far anymore? No, great question. No, man, that's a really good question. You don't lose work credits. They just don't, when they're looking at, realize the Secretary uses something called a 5-step sequential evaluation process. Classic government making a simple process complicated. Step 1, are you working? If you're working, you can't be found disabled. Step 2, do you have a severe impairment? Severe is kind of I'll just leave it at that, but it's just, is it diagnosed? Let's call it that. Step 3, do you meet a listing? If you meet a listing, if you don't meet a listing, go to step 4, can you return to past work? Step 5, you can't return to past work, can you do anything else? At step 5, the burden shifts from you to prove something to Social Security to prove you could do other work. So by making the 5-year waiting period instead of 15, the burden shifts to Social Security earlier, as well as it limits the number of what they're going to assume you could be able to do. But as far as your earnings history, that goes back, 20 years. I can go back however long, last 10 years. Does not change that at all. This is only for analysis of transferability of skills and analysis of capacity to return to past work. That's all that is. Thank you, Cass, for the $5. Okay, well, you know what? That's much appreciated. I will. I would say I buy a cup of coffee. I don't drink coffee, but maybe a hot chocolate, and when it's 90 degrees out, probably not. Maybe a donut. Shouldn't be eating donuts, but maybe I'll eat a donut and raise a donut to Cass when I do. But I appreciate that very much. How many years does it take to get SSDI? It depends. If you apply, I'm telling people, best case 6 to 10 months, more realistic 18 to 30 months. So it can take a while. Okay, Garrett, you're not getting the $5. Sorry. So, but thanks, Cass, anyway. Okay, thank you very much. Mark Tedson. I think I've seen Mark before. Does a Medicare waiting period begin at onset? No. Good question, Mark, but it begins as of the date you are first eligible for payment. First eligibility for payment. So if you become eligible for payment in, let's say your onset date is July of 24, your eligibility for payment is January of 25. The 2 years runs from January of 25, not the onset date of eligibility for payment. Hello, Vinny Mick. After receiving the virtual, I guess this is the VTC, it's your hearing letter. I guess that's a a virtual, maybe as a teleconference, maybe that's you're getting a video conference. How long should you expect a hearing date? Does it matter if you have video hearing or telephone hearing? It doesn't really matter. Both are faster than in-person hearings. I would say this about video hearings. There's a little more that can go wrong in terms of getting the equipment to work. I had one the other week where the judge couldn't get his video equipment to work, and so it delayed everything a while. I've had them had to get postponed. So telephone hearings, there's less technical problems with them, but video hearings are something nice about looking the judge in the eye. So, but they both take about the same amount of time. For the judge, it's the same thing, because they're at their home office or at their office, and whether they use the same program, they use Microsoft Teams. So whether the judge is appearing in person or by video doesn't really matter. And when the judge appears by video from his home, there'll be like a green screen they have, and so you'll see like a Social Security background, and the judge will be wearing a robe. Whether he or she is wearing a T-shirt under the robe or nothing under the robe. Not that I want to think about it that way, but it doesn't really matter. So it's the same program, same process. Donna, again, second recon, what changes submit new medical conditions? Yeah, I think the more new stuff you can submit at recon, the better. You want to give them as many reasons as you can to approve you, and I think new stuff is good. Glenn, I got A. Glenn, you leave me hanging. I don't know what you got A. You got A something. Hopefully Glenn will tell us what he got soon, because he got A something. We don't know what it is. What's the CDR process and how do they happen? CDR stands for Continuing Disability Review. It may happen not at all. It may happen after 1 year. It may happen after 3 years, after 5 years. There's a secret code. And I had a client show me this. When you see the CDR letter, you can look at the code and you can decipher it. But they code your file as to, are you likely to have medical improvement? And if they code your file for a short, a very, very short, review, it could be as short as a year. So it's just, that's what it is. They code it, but it doesn't have to happen at all. But it will be triggered if you go back to work and they see a lot of earnings. It can be triggered by that. Greg Brinkley says no, but I disagree with him. It could be triggered by that. It could be triggered by the nature of your condition. Is it one likely to have medical improvement? Glenn is back. I got approved. So we know Glenn. Okay, Glenn said I got A, but he says I got approved for SSI. Can you explain? That's a special needs trust if I got an inheritance from my father's passing. That, Glenn, unfortunately, is beyond what I can do in this live stream. An elder law attorney would be the person to talk to. And there are elder law attorneys in every jurisdiction, and that's who you need to talk to about a special needs trust. And what it basically is, it's a trust where your money goes into, it doesn't count as your money, so that, like this inheritance, so it's basically goes into trust, so it doesn't count as an asset to reduce your SSI. Is what it is. But I don't do them, but an elder law attorney would be the person to talk to about it. Okay, Sherry, I'm glad that my answer helped you. Speaking of Stephanie, I'm late to the party, but looking more great stuff. Can't get better than this. Okay, well, Stephanie, anytime you want to come on, you're welcome to do it. You have a fan here. I don't know, Steph, I don't know if you realize it. Somebody said before, they hired Stephanie and they're just thrilled about it. And I've actually, people ask me, is Stephanie going to be on your show? And I said, I don't know. I'm going to ask her. GC24 Styles retained you, Stephanie. So whoever GC24 Styles is, that person is very happy to have you. And I'm glad you're here. And anytime you want to come on, you're welcome to do it. I am flawless. I'm a flawless beauty. That makes two of us. Me too. Look at this. Come on. All right. My son has autism spectrum disorder. I applied for benefits in February. When I called, they said it was under medical review. Should get a lawyer to speed up the process or just wait. I'd probably tell you to wait and see if you get approved. If he meets a listing, then you don't need a lawyer. So, and I will tell you, it's hard to find lawyers who take child SSI cases. So, some do, but you may have a difficult time finding somebody. So, on one hand, wait to see what happens because you've already done it. Probably what you need to do. But secondly, you might want to call around to see if there is somebody who would take it if you get denied because it's hard to find people who take child SSI cases because there are a lot of offsets, and it's kind of a separate listings, for example, are separate. It's just a different argument to make, and many disability attorneys only deal with adult cases. Eric, I'm not sure what you're receiving, but I don't know. I'm sure you'll tell me. Pepper Joe has been here before. The possibility of changes coming in 25 with Social Security disability. How should someone prepare their CD? Good question. I think that I would tell you, keep going to the doctor, number one. Number two, keep a pain diary, keep a medication side effects diary. So you got that in your back pocket. You know, if there are people that have observed what you're going through, get their contact information, maybe get them to fill out one of these forms, the 3380, I think is the form that you would have them fill out. Just, you know, keep going to the doctor, I think is the main thing. And just be ready so that if they do review, you've got all the evidence you need. I think the big problem people get into in CDRs is they have not been going to the doctor. They just haven't been going. So, you know, the CDR comes around, they haven't been to the doctor in 3 years. And so Security's like, well, you know, they assume if you're not going to the doctor, you're nothing wrong with you. So that's the problem. I've been fired twice unlawfully for being a liability. You know, again, that's not a disability per se, but maybe that shows there is some issue that you're having with authority, with, you know, following the rules. That could be very relevant to a disability claim. Your feet are always in pain. You can't stand longer than 10 minutes for back and legs start to cramp. I can work with 3 blocks, get Botox for migraines. I'm not sure how old you are, Hits for Life, but, you know, that would limit you, it seems like, to sedentary. If your doctor support that, you know, if you're over 50, you could meet the grid rules. If you're under 50, you know, you've got significant pain, and you can make a functional capacity argument that you would not be reliable because you simply have to take too many unscheduled breaks. So I think that's what I would say there. I've got this thing on, by the way, for review. You know, if you get a chance and you enjoy this live stream, you know, leave me a review. It really helps. I've had a number of people do it on Google, on Avo. Very helpful. And, you know, rather than just put like a 5-star, which I hope you will, but say something like Jonathan's live stream is very helpful. I like his YouTube videos. It really helps. People, you know, will hire me because they said you got really good reviews. And so I really appreciate it if you would do that. And I'm going to put here the contact information here and there. Okay, we're getting about 15 minutes to go. Let's see what we got here. Okay. Okay. That's Garrett says, welcome, Stephanie. Eric, review in 24, 60. They're going to look for significant medical improvement. At 60, you know, it's probably not going to happen. I think that, you know, again, you have a review in January 24, just fill out the form. It's unlikely they're going to move to terminate. Having a review, by the way, is not the same as being terminated, which means they're reviewing you. Fill it out. I think it's unlikely they'll move to terminate you. All right, Jen from my office tells Jim Tuski, and Jen is the person in my office who deals with all the forms and the medical records, and she makes a good point. You know, make sure that, and this is about preparing for a hearing, make sure your medical records are up to date. That's a very good point. You know, you don't want to go to a hearing with the last record 18 months ago. So part of the prep work is to make sure you let your lawyer know, or if you're doing it on your own, all your records are up to date. And all those forms, you know, we're talking about the medication form, we're talking about the recent medical treatment form, we're talking about the work history form. They need to be completed. And, you know, sometimes if you don't complete them, judges get a little ticked off at a hearing. So, you know, that would be something to go ahead and get done. I think Jen makes a very good point there. Okay. Case involves IBS, bipolar suicide attempts, gastro doctors, an osteopath. Gives me an IBS. I don't think an MD versus DO makes a big difference. They're both, you know, considered to be authorized or approved medical sources. Although if you're getting an IBS diagnosis, a gastro is probably better than an osteopath. But, you know, a medical doctor is better than a chiropractor. So, but I think if you can get a gastro, that would probably be better. Let's see here. I think you asked this before. I don't know, and again, I put the link in the directory. You can take a look at that. Okay, so Jen gave us the name of the forms here: the 46, 31, 32, and 33. By the way, Jen is a new grandma, so I say congratulations to Jen. I've got a 10-month-old grandbaby. Jen has she's much younger than me and has has a grandbaby that just got born a couple weeks ago. So we're all very pleased about that. Everybody's healthy, which is the most important thing. But yeah, she makes a good point that make sure your medical records are up to date, and those are the forms. Can you reopen an old SSDI case if denied? Again, it depends. This is starting to get a little technical, but if you were denied SSDI, you've got to appeal that denial within 60 days. If you don't, you can't really go back and reopen it, generally, unless there's some really extenuating circumstances. So I would say it depends on when your denial came in. There's Garrett telling us, give me an email, you're hired. All right, well, we got workers' comp. That's going to be a problem, because if you're getting workers' comp, then you're not going to get disability. And I realize I only get paid if I can collect past due benefits. You're getting workers' comp. Workers' comp offsets your benefits. There's no past due benefits. So, unfortunately, I can't take a case with those ongoing comp benefits being paid. Again, contact me and we can talk about it. But if there's ongoing comp, no. Stephanie says, I'm awesome. Well, I'm not going to disagree. Stephanie's a very smart person, so who am I to disagree with that? Arthur says, thank you. You're welcome, Arthur. The appeals council just remitted my case back to the local hearing office. Was expected next another hearing, just like you had before, but with some direction from the appeals council. Best way to get my radar is to complete a free case evaluation link pinned to the top of the chat. Okay, that is the best way to reach me. Yes, that is true. Can you receive SSDI? I had it happen. I got a case on Friday where the guy had it happen. So yes, it can happen. He's got what they call presumptive SSI. I rarely see this, but they can give you SSI based on the likelihood of being approved and your financial need. And I have a client who's getting SSI as of January of this year, and our hearing is this coming Friday. Let's see. Okay, so Malik had an SSI appeal hearing today. SSD or SSI, but he had a hearing today with schizoaffective disorder, part-time job. They want to see your pay stubs to see whether you were going over SGA. Maybe you can use your trial work period, but they want to see if you're working, how much you're working, because if you're working over SGA consistently, then that would be grounds to turn you down, even if you medically qualify. So yeah, that's why they're asking for all that stuff. Okay, Nomad. Well, I appreciate that very much, your kind words. And again, good karma. I think if you put good stuff out in the world, that comes back to you. And again, if you would, if you will review me, that would be great. I'll put the review here. Let me go ahead and stick this over there. Leave me a review. That's great. Obviously, not everybody's going to hire me. That's fine. But leave me a review. bit.ly, Jonathan-review-5. That would be very, very helpful. And again, that's how to contact me. If you'd like to do that on this bottom scroll here. Okay. All right, so we got about 10 more minutes here. Okay. Spirit Stalker, 54, been waiting an SSI decision, do a phone interview about income and bank information. Again, your income could offset his SSI. It just depends on how much. There's a lot of factors with what they call the deeming rules, and I don't want to, I just don't want to get into that because it's much too complicated to kind of talk about. But I would tell you that you want to maybe talk to an elder care lawyer about that. The same person who might do a special needs trust. Maybe that's something you could talk about. All right, DeBurn, submit info right now. Great. I will take a look at it and we'll get back to you tomorrow. Okay, that means Jack wants to know what it means when that you're getting a non-medical review. They're looking to see whether you're working. If there's been any earnings. That's what they're looking for. If you've been approved medically, but they want to see if you had earnings. Local county court determined permanently excused from jury duty. It's a piece of the puzzle. It helps, but it's not conclusive. Just like a handicap parking spot or placard doesn't. It just means that somebody has made a decision. It's a small piece of the puzzle. Can't hurt. Won't win your case on its own. Can grid rules be used? Absolutely. Absolutely. But anxiety disorder and OCD are not exertional impairments. The grid rules only apply when you have physical limitations. It does help to be over 60 in general, because Social Security's got a bias for people over 60, but the grid rules only apply if you have functional physical issues. Florida has been diagnosed with Sjogren's at 50 after years of challenging my teeth and now crippling fatigue, brain fog. Could be, again, you need your doctor to talk about the degree of impairment, how it impacts you on a job. Okay, so we're getting close to the end here. Classy hood rats. Can you be a classy hood? That's an interesting, that's like a jumbo shrimp, military intelligence. These are what's the term for it? There's a term for it where you have two contradictory phrases. So classy hood rat seems to be a oxymoron, what it is. Okay, served 27 years, was a designated wounded warrior. Thank you for your service. Medically retired in 2019 for PTSD, have not worked since. Hearing in October. I think that if you are getting 100% VA, I don't know if you are, that can help a little bit. But, again, I think that judges are sympathetic to people who are wounded warriors. If you're medically retired, that helps. But again, they're going to look at your underlying medical records, and hopefully they will do the right thing. And again, thank you for your service. I think that you just need to talk about what the triggers are, and talk with your lawyer about this beforehand. What are the triggers for the PTSD? What are the things that what happens when you have a trigger? What are the flashbacks? Does it take you out of the present? Does it affect your sleep? Does it limit you in interacting with males, with females, with people in uniform, with loud noises? Gets very specific, get very granular as far as what does it mean? That's what you want to focus on. I'm not sure what TANF is. So Connor's Canine Cookies, don't know. I'm getting low on time, so I don't know what TANF is. But if it's not, most of these type of benefit programs do not have an SSD offset, so probably, but I don't want to say for certain because I don't know what TANF is. Is the 3380, I would say better. It's just more detailed. It goes into some details. So I think if you can get one, yes, the third-party form. If you can get one, that's great. If you have to use there's a statement from a claimant or third party, just a regular statement, you can use that too. But I think if you got the 3380, that's good. But you don't have to have it. But yeah, I think everything else we equal use that form. Just getting VA disability, it's not binding on Social Security. It certainly doesn't hurt. It'll get you a faster decision. And it can help a little bit. They take it under acknowledgement, but you have to win because the standard for disability is different. So it helps, but it's not determinative. Let's see, medical. Okay, can a judge deny me if their consultant gave me a favorable report? My medical record shows backload of medical evidence. Again, the more evidence in your favor, the better. So, the judge can still find a reason to deny you, but the more evidence you have, the better. I had a hearing this week where, the judge was actually a little bit hostile. He was like, my client had gone to a consultative evaluation and the doctor spent like 10 minutes with him, so I had to testify about that. And then there's a woman, and she also had another consultative evaluation that was 60 miles away. And she's like, I couldn't get there. And the judge is like, don't even start that. He starts yelling at me like, well, they'll pay for that. And you don't go there. And he's just like, I'm like, okay, drop it. I'll drop it. And after all that, he's giving me a really hard time about this, which again, think about it. You have transportation, you got to go 60 miles for a consultative evaluation. And if you look at the forms, it says, yes, we'll pay for transportation, but it's really in very small type. I mean, it's not real clear at all. but at the end of the day, he's probably going to prove the case. So, he yelled at me a little bit. I'm not going to yell back. I'm like, okay, and so, I think that the judge can find a reason to deny you, but you want to give him reasons to not. Okay, so I think Garrett says, okay, to burn, so we did receive it. Okay. All right, I'm going to have time for a couple more questions. Thomas is, I'm 59, I have a bulging disc in your neck and lower back, shots in my back every 6 months, knee replacement, heart disease in 12. Okay, I think at 59, you based on that, I think it's reasonable to think you'd be limited to light work, and there's going to be some pain there. So I think that says to me the grid rule 202.06 would apply. I think that'd be a pretty good argument. That's what I would try to argue, at least. Okay, the dude has been here for 2 hours, so we got to answer the dude's questions. I have a 12-year-plus-old trial heart valve replacement. Let's say I'm a big pork supporter. 58. To put it nicely, my heart is feeling my age. How does that say? Heart valve conditions. Okay, so I'm guessing what you mean is that you eat a lot of bacon and maybe not the healthiest eater. You've got a heart valve replacement. Again, I would tell you that if the heart valve is not giving you problems, you're not going to win disability because of what something might happen. If it is giving you problems, if you are, finding yourself short of breath, okay, that's one thing. If your doctors are telling you you've got to have a heart valve replacement and your activities have been limited accordingly, that can help. But simply having a heart valve that is old, that's probably going to need to be replaced, and you're not eating healthy, but nothing has really changed in terms of your functioning, that does not win your case. That's what I would say. But you're feeling your age, at 58, that tells me the grid rule. So maybe there's enough there where you could say, I've got this, plus I've got other stuff going on as well. Okay, yeah. Jen notes that the 3380 asks detailed questions about the disabled person. Okay, I'm going to have time for a couple more. And Suzette, mom of 3. Hello, I've not worked since 2012 due to dislocated disc in my back. Settlement from workers' comp, went through that. Okay, so if you don't work since 2012, the problem is you're not going to be insured because your insured probably ran out in 2017. So, because it runs about 5 years after you stop working. So, can you prove you were disabled in 2017? A real uphill battle. If you're trying to say you became disabled in 2020 or 21, you're an SSI only because you're not going to be insured. So it is going to be difficult. And of course, the settlement for workers' comp needs to have that language in there. I don't know, how old are you? If you're 55, 56, that's going to help. If you're 48, not as much. So the dude, I think that's the key, is your condition deteriorating. You've got to show why it's deteriorating medically. Okay, so Teresa says, congrats to Jen, and Jen says, thank you. So the dude, I'm not trying to blow you off, I'm just saying is that at the end of the day, there's got to be some medical evidence that supports your case. The DO is a gastro. Okay, MD gastro would not be better. No, I think a gastro DO is fine. Okay. All right, we got time for a couple more questions. Okay, actually, legitimate questions. Okay. How do I do this? Okay, chill mode. Chill mode got in here late. 7 knee surgeries, 2 meniscus repairs, and a partridge and a pear tray, 2 replacements, revisions, blah, blah, et cetera, et cetera, et cetera. Yeah, I think that those are all pretty significant accidents. Can't even handle receptionist duties. Yeah, I think that, again, you don't say how old you are, chill mode, but those are some pretty significant problems. That says to me that there's a pretty good argument you've got for disability, I think. Okay. Donna says, thank you again. Okay, so I think that's kind of where we're going to end it all here. All right, well, I appreciate everybody. We've been here for about 2 hours now, which is my normal time. I really appreciate everybody coming in. We had about 100 people today, So we're going to work on trying to get us to 200 at some point. I'll answer all those questions. I'll have to get Stephanie to help me. But I appreciate everybody coming to stay with me, to spend their Wednesday afternoon, evening with me. And again, if you have any questions, you want to contact me, use the bit.ly contact3. And if you are so inclined to leave me a review, please do that here at Jonathan-Review-5. Or just go to jonathanginsberg.com. You can do it there too. But I really appreciate that. I'm glad that everybody got a lot of questions in, and I hope that everybody has a great week. Stay cool out there. The heat can be really, really dangerous. So stay, inside when you can, if you need to, if you're susceptible to that. And hopefully everything else, goes well. We will see you all next week. So I really appreciate everybody coming to spend some time with me again, and I'll end this right now, but have a good week.